Well, welcome everyone. Welcome to the newest season of the Dignity Rights International Reading Group. I'm Erin Daly. I'm the Executive Director of DRI, and with me is Jimmy May, the co-founder of DRI. Last season, we started our round the world tour of dignity rights scholarship with presentations about dignity in law and culture in Asian societies, and with a broad overview of dignity in international law. This season, we're continuing this theme with presentations about dignity in the reforming legal system in Bhutan with Stefan Sonnenberg, who joins us here today. About the role of dignity and law in revolution in Egypt, the Arab Spring, and we'll finish off the season with a talk about the relationship between dignity and democracy in Europe. Today, I'm absolutely thrilled to begin our season with Professor Giorgio Resta, who joins us from the University of Roma Tre, where he is the full professor of comparative law, the coordinator of the International PhD program on law and transnational regulation, and the deputy dean in the Department of Law. And with all that, he still has time to think and write about the ways in which courts and society understands dignity in law. He's written extensively about the judicial recognition of human dignity in criminal law, tort law, and in other contexts. Today, Professor Resta is going to discuss his work at the intersection of dignity rights, historical memory, and law. His remarks are based on his recent article, Civil Responsibility and Historical Injustice, the Case of Nazi Fascists, which focuses on the litigation related to Nazi and fascist crimes of World War II, which has led to landmark decisions by Italian courts, rethinking sovereign immunity and other major issues in the name of human dignity. So please join me now in welcoming Professor Giorgio Resta. Before he begins though, I would like to see if we can just go around the Zoom room, as it were, and invite everybody to just introduce themselves, just so we all sort of know who each other is. So Jim, since I pre-introduced you, why don't we start with you, and then we can just sort of go around so people can meet each other.
Nice to see everybody. I'm Jimmy May. As Erin mentioned, I'm co-founder of Dignity Rights International. Thank you so much just for joining us. And I teach at Delaware Law School as my home school, and I'm presently visiting at the Elizabeth Howe School of Law at Pace University in New York. Nice to see everyone.
Just to go in the order in which you appear on my screen, Stefan.
Hi, my name is Stefan Sonnenberg. I'm joining from Seoul, South Korea right now. That's where I teach also.
And as I mentioned, he'll be our next speaker in this series.
The audio may have cut out.
I'm sorry, I might have. Yeah, Erin, could you introduce yourself?
Hi, everyone. I'm Erin Samarasinga, and I'm the Grants Officer at Delaware Humanities. Happy to be here.
We're happy to have you here. Eileen.
Hi, I'm Eileen McCarthy. I'm in Washington, D.C. I'm a retired lawyer, and I just got interested in these issues when I attended an ABA forum. I work on pedestrian rights, and I'm on the board of the International Federation of Pedestrians. That's my sort of avocation.
Fantastic. And Eileen, I think, has been at pretty much every single one of our reading group sessions. So it's
I missed the last one, but
okay. All right, thank you. Lubim, great to see you.
Thank you very much, Erin. Good evening. Good to see everyone in the call. I'm Lubim. I'm calling in from Abuja, the capital city of Nigeria. I'm a trained political scientist, a career journalist, a publisher, and now I work as a legislative assistant in our national parliament, and married with 2 kids. It's so good to be with you here. I hope to enjoy my stay here. Thank you, everyone.
Fantastic. It's great to see you here. Thank you. And Sandra, see you.
Hello, my name is Sandra Rios. I am in The Hague in the Netherlands. Although I am a researcher at the University of Louvain at the Institute of Political Science, and I'm interested in the topic of dignity, particularly in the context of transitional justice in Colombia. That's what I do my research mostly. Thank you.
Thanks so much, and welcome to everybody. I know we'll be joined by a few more people along the way, but for now, let's begin with Professor Resta. Please begin. The floor is yours.
Thank you so much, Erin. Thank you, everybody. And I'm so happy to be here. Thank you so much for the invitation. It's really an honor to participate to this reading group. And I will not give a formal presentation with slides and so on in the spirit of an ongoing conversation. So I reflected upon the topic because when Erin invited me to talk about dignity, I'm currently studying the digital rights, data protection issues, but I've always had a particular interest for the topic of historical injustice. As Erin said at the beginning, I wrote some papers on this field, and I thought that this was a great occasion to try to tell everybody what's happening in Italy, because generally we are more informed about the American, North American, South America, or even East Asian development in this field. But Italy and the Netherlands, as I will say later on, are becoming, particularly in the last years, a very important laboratory for reflecting on the relationship between law and history. So let me shortly introduce this topic, because I think it's quite important to stress the general framework. And that is to say that in the last years, we are witnessing a very important phenomenon of a juridification, a word that is meant to translate the German Verrechtlichung, that is the absorption into the law of history. So history has been increasingly juridified, and despite the fact that law and history have a long-lasting relationship, because law has been defined as frozen history. Law deals with norms that have validity over time, and law is the product of historical conditions. So historically, we've been used to talk about a history of law. No? But since at least the end of World War II, and in particular in the last years, we are witnessing an inversion of this relationship, in the sense that law is no more the object of history. It is becoming more and more the subject of history. And history is has to be taken from two different perspectives and in two different meanings, which have been very clearly distinguished by the great French historian Jacques Le Goff. So the first meaning of history is related to what the Latins called the res gestae, the facts of the past. This is the first basic notion of history that we deal with. But there is a second meaning of history that is important to take into account to understand the role of the law, and that is history as historiography, writing and talking about history. So as a matter of fact, in the last 50 years, the law increasingly regulated not only the effects of the historical facts, and in particular, the historical injustices, but it also regulated to an increasing extent the way in which history is written and told. So the law became a vector of memory, also by legislation. And one very important development is the very well-known phenomenon of memorial laws throughout the world. In particular, the most famous is the European, in particular the French development in the field of Holocaust denial, but also other types of genocide denials have been prohibited by law, and the law has imposed a certain truth about history. And there are plenty of decisions of the European Court of Human Rights on the freedom of the historian and the limits of this freedom that cannot become a form of abuse of rights. So the law is increasingly regulating the effects of history and the way in which history is written and told and retold in the present. But I would like to focus not on this second part of the story, which is also very interesting, but of course I do not have time to deal with this very intriguing aspect of the regulation of history, writing and telling, as I would like to share some thoughts on the problem of the reparations for historical injustices. Let me say also as a sort of introduction that the reasons behind such growing convergence between law and history, also what has been called the retrospective politics, are various and multi-phased. The end of Cold War, post-colonial struggles, the growing importance of the judicial branch in comparison with the parliaments. But above all, I would like to point out to the growing value recognized to the fundamental right of respect of human dignity all over the world. We are witnessing from this particular perspective a sort of individualization or even privatization of claims for historical injustices, claims which were in the past absorbed by a purely statist dimension, enshrined in a sovereignty-based international law. And this is immediately visible in the specific issue of reparation, but also the memorial legislation, to which I said something before, has been used in Europe lastly as a basis of individual claims, couched in terms of the violation of the right to personal identity against the proponents of negationist thesis. But let's focus now on the first prong of the issue, the privatization of reparation. Antoine Garapon, the famous French judge and legal scholar, wrote recently that the juridification of history has gone through three main stages. First, criminalization, preponderance of criminal law. Secondly, reconciliation, transitional justice and the Truth and Reconciliation Commissions all over the world. And lastly, reparation in the sense of material and non-material satisfaction. But more precisely, in this last stage, we witness a clear trend from public international law to private law. War reparation as the model of intergovernmental agreement has been gradually supplemented by tort law as a vector of intergenerational justice. Paradigmatic is the example of the US Holocaust litigation based on the universal jurisdiction offered by the alien tort claims, or the litigation currently ongoing in East Asia, in particular in South Korea. And it's fantastic that Stefan is here and is probably knows much more than I do on this topic, with regard to the crimes committed by the Japanese army in World War II. But also, as I said at the beginning, I think that the most recent experience in Europe is particularly significant because it is not generally known or discussed. In the literature, the assumption is widespread that Europe came to terms with its infamous past mainly through non-judicial instruments, such as the compensation schemes, memorial laws, and truth commissions, whereas other jurisdictions took an opposite trend. This was probably true in the past, in particular if we look at the German experience. But today, I dare to say that the picture is starkly different. Tort law is becoming a valuable tool, if not for achieving the purpose of compensation, because of some technical hurdles that still have to be solved, at least for the aims of what has been defined recently, discursive justice. That is a form of justice that brings the victim's claim to the fore of public opinion by using the instruments of the judicial adjudication. The Netherlands, from this point of view, has undergone an intense process of confrontation with its colonial past, mainly as a result of a successful private law litigation brought before the Dutch courts by victims of state crimes committed in Indonesia and other territories under the Dutch colonization. And the Dutch experience is particularly interesting, but I will not deal with this specifically today, because it is one of the few examples in which domestic courts arrived at the outcome of a conviction for damages of their own state. Exactly the opposite, for example, if we take into account the Japanese experience and the litigation brought by South Korean women for the enslavement during the Second World War, or by other Chinese civilians and South Korean civilians deported and enslaved, put to slave labor in Japan. Most of this claim, the largest part of this claim, was rejected by the Japanese courts, but they found, as we know, in the end, a profitable outcome before the South Korean courts. But the Netherlands is particularly interesting from this point of view, because it is their own courts that convicted the state for the crimes committed abroad at the time of colonization. But the most striking example, from my point of view, is the Italian one, because Italy has experienced one of the most courageous phenomena in the field of reparation for systemic violation of human rights. It is worth noting at the outset that this litigation concerned almost exclusively Italian victims of atrocities committed by the German occupation army and also by fascist forces during the occupation of Italy after 1943 in World War II. By contrast, to date, no lawsuit has been brought against Italy as a former colonizer and occupying force in Africa and other territories. But we may not exclude that the Italian Republic, exactly and specifically on the basis of the doctrines put forth by the courts in the cases that I will going to discuss in a while, will sooner or later be involved as defendant in a similar lawsuit brought, for example, by victims in Libya, Ethiopia, or Somalia. So the confrontation with the past in Italy followed different routes, which I try to better explain in more details in an article published a few years ago in the Law and History review about the massacre of the Fosse Ardeatine, the Ardeatine caves, committed by the German forces as a reprisal for the famous partisan attack at Via Rasella. So until the 60s, the stage was mostly taken by the rare trials of Nazi officers before the Italian military courts or the Allied military courts, with few convictions and some scandals, such as the escape, which probably was aided and supported by the Italian and German secret services, of Colonel Kappler from jail. After the 90s, the discovery of the so-called armoire of shame led to the reopening of old files, forgotten files, concerning massacres and other violent crimes committed by the German occupation army in Italy. New prosecutions were launched, and among them the one concerning Captain Priebke, Erich Priebke, one of the persons responsible for the Ardeatine Caves massacre, which led often to different outcomes compared to the military trials led in the aftermath of the armistice. Three elements need to be underlined to better understand this development, and in particular, the development of civil trials, starting with the 90s. So, when the Constitutional Court in 1994 declared the invalidity of a provision of the Criminal Military Code, which prevented the normal citizens from intervening in military trials to ask compensation for individual damages, the judicial confrontation with historical injustices started for the first time to consider not only the public law dimension, but also the private law, and namely tort issues. The situation became even more pressing when the last German officers died, and therefore the German state started to be directly sued as vicariously liable for the torts committed by its employees. At the beginning, when there were still some officers alive, they were prosecuted. But given the death of most of these officers, criminal law was muted, and therefore victims started to resort to the tort lawsuit against the German state. And tort law started to be perceived as an invaluable tool to achieve some form of intertemporal justice, something that criminal law cannot be used for. At the same time, there were some compensation schemes which were put in place by Germany in the framework of various bilateral agreements with Italy, the last one dating 1961, and similar schemes were adopted with other countries in order to solve all the debts and issues related to the Second World War. But this compensation scheme left many victims completely and fully uncompensated. And in particular, the about 800,000 Italian military internees whom were disarmed after the armistice of September 1943 and deported to Germany to be sent into forced labor without receiving the status and treatment of prisoners of war, it seems under a specific provision coming from Hitler, were excluded from any compensation scheme. So another reason why victims started to abandon the public law model, and they tried to use tort law as a form of satisfaction for what they suffered unlawfully during World War II. And we have in this starting litigation at the beginning of 2000, two main categories of victims. On one hand, the former partisans and civilian victims of deportation or torture or similar violent crimes. On the other hand, the military internees employed as forced laborers in Germany to the benefit of German industries. But the main obstacle in this first litigation was represented by the doctrine of state immunity, which was for the first time overcome in the famous Ferrini ruling of the Italian Supreme Court in 2004. In this landmark decision, which was specifically used and referred to by the South Korean courts that in 2021 granted compensation to the victims of the women, South Korean women, victims of crimes committed by Japan in World War II. Ferini decision was specifically mentioned in these cases. The Italian Supreme Court not only affirmed that immunity is not applicable with regard to crime against humanity, but also reinterpreted the claims agreement as not involving a waiver on behalf of the Italian citizens by the state, waiver of claims for compensation of damages. And exactly the same argument has been used by the South Korean courts. Those courts, and we know that there is contradiction between different tribunals in the same legal system on this point, but this argument was used in order to award compensation to the victims suing either the Japanese state or the Japanese corporation that profited from slave labor in Second World War. Well, but this is just the beginning, because new rulings followed the Ferini decision at the level of first instance appellate courts until in 2012, the International Court of Justice condemned Italy for breach of international law, having denied the jurisdictional immunity of Germany. As a result of this decision, the Italian Supreme Court suddenly changed its position, recognizing the direct and immediate applicability of the ICJ ruling. Other courts followed suit, and even Parliament intervened on this topic by passing a law, number 5 of 2013, imposing compliance with the ICJ decision. However, the Tribunal of Florence, in a case of a tort suit brought by one of the many victims of the German crimes, the Tribunal of Florence was not convinced of this position and raised a constitutional issue before the Italian Constitutional Court. In 2014, 10 years after the Ferini ruling, the Constitutional Court made an unprecedented move, affirming that the customary international norm of state immunity cannot enter the Italian legal system as far as it leads to the exclusion of any judicial remedy for victims of crimes against humanity and other gross violations of human rights. This result, argued the court, would be against the fundamental principles of respect for human dignity and access to justice. I quote from this ruling: "In the present case, the referring judge has not casually indicated jointly the Articles 2 and 24 of the Italian Constitution, inextricably linked in the evaluation of constitutional legitimacy requested of this court. The first is the substantive provision placed among the fundamental principles of the Constitutional Charter to safeguard the inviolability of the fundamental rights of the person, and above all, relevant in this case, human dignity. The second is also to safeguard the dignity of the person, protecting her right to access justice in order to assert her inviolable right." So dignity is specifically used by the Constitutional Court as the basis of an intellectual operation aimed at affirming the prevalence of the fundamental rights on the customary principle of international law of state immunity. So human dignity against state reason sovereignty immunity. Following this decision, the ordinary courts and the Supreme Court came back to the original path, abandoned after the ICJ ruling, denying the sovereign immunity of Germany. Dozens and dozens of cases were decided since 2014, dealing with infamous episodes of tortures, mass executions in reprisal for partisan attacks, deportations, forced labor, murders of civilians. Of all this litigation, which is particularly rich, I think that at least 3 aspects deserve to be specifically noted. First, in most of these lawsuits, Germany did not participate to trial because it did not recognize the Italian jurisdiction. By contrast, with an apparent paradox, the Italian Republic intervened in the trial proceedings, but not on behalf of the victims, the plaintiffs, but on behalf of the defendants, Germany, and against the claims lodged by its own citizens and against the position taken by the Italian courts. And this was done in order to comply with the ICJ ruling. But still, this is quite striking. Secondly, despite the fact that the largest part of the lawsuits were technically successful, they proved practically useless, as the principle of a sovereign immunity from execution still prevents taking measures of constraint against the property of Germany to satisfy the demands of creditors under court decisions. The victims knew this, but nonetheless, they decided to sue Germany and to support the costs of the litigation. And this is, from my point of view, particularly striking because it is a clear demonstration of the idea of discursive justice. So here we have plaintiffs that are not suing for money, despite the fact that this is a tort claim, but they sue in order to have an objective and impartial ruling testifying the harm suffered by them or by their ancestors. And this is quite telling of the importance that the victim might put on a civil action, and this is not just for money. Third point, the physiognomy of tort law, conceived as a tool in public law litigation, was consequently significantly altered, as it was similarly demonstrated in other instances of public law litigations abroad. For example, in the Dutch cases, the courts gave a very large and flexible reading to some of the, so to say, technical pillars and requirements of a tort action. First of all, the courts said very clearly, and in some cases against the letter of the agreements, that by signing a bilateral agreement with Germany, Italy, as a state, cannot waive the tort claim on behalf of their citizens. So this is once again a demonstration of the importance of the idea of individualization of remedies in contemporary law, something that in the past would not be accepted. Secondly, as regards to the subjective scope, we have cases in Italy in which not only the direct victims of the wrongs have been admitted to sue, as obviously, but also the descendants, first and second generation at least. Not only these people, but even in 3 or 4 important cases, the municipalities. In some cases of mass execution committed by the German occupation armies in reprisal for partisan attacks. We have 2 or 3 rulings in which the town of Roccaraso or similar municipalities have sued against Germany, and they recovered material and immaterial damages for the loss suffered by the community as such, and not only by the individuals. And this is again an enlargement of the general subjective scope of tort actions. Burden of proof. In many cases, we see that the courts are being very generous in considering the claim proved despite the absence of univocous, unambiguous documents or witnesses. And this is easily to understand if we consider that in many cases, for example, the deportation into a concentration camp that led to the death of a person was never recorded, or the written records cannot be found anymore. Nonetheless, the courts, by using historical proofs, so documents by historians or oral witnesses from other people reported into some of these history books, arrived at the conclusion that the claim was sufficiently proven. Damages, as I said, in the case of municipalities, courts have been quite flexible in awarding pecuniary and non-pecuniary emotional damages for the wrongs suffered not only by the first-degree victims, but also by the victime par ricochet, as the French would say, even the municipalities. And lastly, but probably most importantly, prescription and time limits have been intended by the courts in a very pro-plaintiff way. The Italian courts, differently from, for example, the Japanese courts, and in some cases the Dutch courts, said very clearly that these claims in tort, despite being formally barred by the lapse of time, because in Italy it's 5 years, they said that being crimes against humanity, the idea of imprescriptibility, which is typical of the international law perspective on human rights violation or crimes against humanity, has to be applied by analogy also in private law. So whereas, for example, in the Netherlands or in South Korea, some courts gave an equitable explanation in order not to apply prescription, because they said it would be against the principle of abuse of rights for the defendant to use the defense of prescription. The Italian courts said very clearly that these torts have to be considered unprescriptable. And this is again a very important transformation of the law of torts in order to, so to say, satisfy the peculiar needs of granting a protection to the victims of such serious crimes. So, and I conclude, I think that this development, which is not only Italian, as I said at the beginning, is very interesting because it shows that some traditional boundaries are being blurred. First, the boundary between politics and law. Things that in the past were left to the reason of state, to the, let's think, for example, of the Treaty of Versailles that ended First World War, now became a legal issue, decided on the basis of an adversarial logic with guarantees of transparency and impartiality. Secondly, the boundary between public and private. Things that were left to public law oriented compensation schemes tend to be managed today through the traditional tools of private law, in particular the law of torts. Not exclusively, but so to say, cumulatively, both together. Third important point, the alteration of or the blurring of the boundary between the judicial branch and the executive branch. Things that were considered exclusive competence of the government are decided today by courts. And this, once again, if we want to give an explanation for this transformation, I would not find something more clear and unambiguous that the idea of human dignity is an important reason to change the way in which historical wrongs have to be managed today by our communities. And despite the fact that some scholars have criticized this evolution by saying that there is a privatization, sometimes a commercialization of mass crimes, I think that it is very important to take into account the Italian experience, because it shows very clearly that finding an impartial and objective forum in which wrongs are adjudicated and are recognized as such is what the victims want in many cases, more than just material or pecuniary damages. I would like to stop here and continue probably in the conversation.
Thank you. That was fantastic. Just that was really, really interesting. So I know the applause are muted, but I think they're heartfelt. So let me just open it up to people in the audience here who might have questions or thoughts or contributions to make. I know some of your work, and I know how some of your work sort of has been talking about. So I would just open up the floor, and please just jump in if there's anything you'd like to contribute or ask about further.
Well, I'll just jump in here. I don't know. Maybe I'm not smart enough to come up with a question right now. I just actually really want to thank you for your presentation and your really clean and sort of organized breakdown. That to me was such an interesting presentation, because as you've obviously foreshadowed many times, I've been consuming the Italian cases sort of as they sort of made their way into the South Korean case law. And what's interesting is they also, to me at least, or what I'm sort of thinking about is, to me, there's right now a big push to also think about whether some of these, how would one go about bringing accountability for inter-Korean issues between North and South Korea. And there have been a few tort law cases against North Korea that were brought in South Korean courts already. And then and they were successful as well. And those were in the cases of basically people, prisoners of war who were then put in who were then sort of taken to North Korea, and they kind of had to do essentially slave labor there until eventually they were able to escape many, many decades later. But there are a lot of lawyers right now, and actually there's just in a few days, there will be a center that's founded to start really thinking in a systematic way about attempting to bring, well, some account, really like very open, how would one bring accountability for, the many issues that are happening in the North. And so I actually feel like what you're talking about, the kind of renaissance of cases that came after 2014, could actually also very easily happen here. But that's not a question. But I just really want to thank you for your contribution. And I was taking notes wildly because I think some of these conversations might continue if you were interested ever.
If I may jump in, thank you, Stefan, for your comments. I personally am extremely interested in understanding more of the South Korean experience, which is extremely intriguing from many points of view. Not lastly, because if I'm correct, this is one of the few examples in which courts granted execution on property of the Japanese state after the Mitsubishi decision, in which corporation and then the Japanese property was involved in the specific wrongs at issue. And this is something that in Italy was still not done, at least openly in these specific cases. Because the problem is that if we even arrive at an erosion of state immunity, but then we don't have the possibility of grasping and executing on property, then it's going to be, so to say, a reduced form of justice. And I think that South Korean is extremely interesting from this point of view, what they are doing. And I might be interested in understanding also what is the opinion of the population given the contrasting solutions given in 2021 on the state immunity.
Yeah, well, just briefly, sort of my personal impression. I'm not sure that there is so there is contrasting case law from the same court on this issue. Basically, the different panels on the same court, one of them decided in favor of sovereign state immunity. The other said this, basically depending on Ferini or relying on Ferini, said no, we'll go forward. That case then led to a massive trade war, which you might have heard about, right? Like Japan basically removed South Korea from the most favored trade nations status, which restricted Korean firms from having access to all these kind of minerals and whatnot that they need to make semiconductors. And of course, this being a geopolitical state, right, in East Asia, the United States is trying very hard to get everybody to play nice, but the Korean and Japanese diplomats are, in a absolute Cold War mentality towards each other. And it's really in many ways precipitated by this case. So the costs, I'm not an economist, but one could calculate the costs at probably, a lot of money, right? It really, and the economies are so intertwined that there's massive popular boycotts. Nissan isn't selling cars here. Hyundai isn't selling cars in Japan. I mean, it's a massive impact on the economy. And so what it's caused is a bit of a polarization, particularly a sort of right-wing rallying cause, right-wing rallying cry in both places. So it is interesting how it will play out. And what's very interesting is that the victims themselves, the survivors themselves, in the case of the Harmony, the comfort women, or I think more appropriately, the sort of female victims of sexual slavery, they are being instrumentalized by these very right-wing sort of, they're sort of almost nobody's talking to them anymore because it's not about them anymore. So that was actually really nice to hear how in your presentation, it does sound like the survivors or the victims or even the municipalities are actually still at the center of the discussion. I think that's, at least from the perspective of those who care about that, that's sort of interesting to see how that stayed there.
If I can just jump in, I think that's exactly, one of the aspects of Giorgio's sort of the narrative that you gave that's so interesting is about the dignity the aspect of dignity that allows people to control their own story and to be at the center and to present their story as they want to. And it's an interesting contrast that you're pointing out. And also, I just want to mention, sort of, in addition to sort of the many layers of dignity that we can see in these stories, both in Korea and in Italy, but in addition to that, and complicating it, is the different ways that dignity is conceptualized in Asian societies compared to in Europe. And there's discussions around that also. I want to bring Lub and Gemma into the conversation also. I think your hand was raised.
Yeah, thank you very much. And thank you, Resta, for that wonderful presentation. And it goes a long way to show that what happens in one place happens everywhere. I think there's even a saying in law like that: an injustice to one is an injustice to all. And my comment is not really going to be general in the sense that I'm attending this call for the very first time and I don't have a full grasp of what actually happens here. But I want to quickly mention that in my country too, treating people with dignity is becoming a very, very serious problem. Like I had discussed with Erin about a week ago, we were under a military rule for several years. So people's mentality has been moved into brutal use of brutal force, use of a lot of energy to do things that should be done with human face. And in my country here, like immediately you are accused of an offense, it's possible that you will be subjected to a media trial. What do I mean by media trial? Before the court listens to your case, because before you're taken to court, the security agency will have to parade you in the presence of full-blown media arrangement. You know, they treat you shabbily, they ask you silly questions in most cases, and then they assume that already you are guilty. You know, so this has been, for me, I have been in the media industry for about 14 years, and it's in Abuja here. So I come face to face with such cases, and we feel very, very bad in most cases. Because in the end, some of them don't go against the person that is accused. In most cases, but the damage has been done. Like I take a loan from somewhere, I'm unable to pay in time. Before you know, you are like, your name is everywhere on social media, conventional media, you're a fraudster, you are this, and your family is bad. And you know, a lot of things happen. But I'm very, very happy and I'm pleased to listen to this conversation, because I know that is the beginning of good things to come in the whole world. What is happening in the global north is so replicating itself in the global south here. And I can tell you that here is actually a worst case scenario. Quite frankly, I must tell you this. And the earlier we think we can harmonize efforts, cross-fertilize ideas, and bring such learnings, like bring such conversations into the global south, particularly in countries like mine, you know, the earlier will be better for all of us. Because as we speak now, we are going into election year. Politicking has commenced already. You know, we hear a lot of funny stories, and people sometimes, character assassination is everywhere. I'm in party B, you are in party C, or maybe you are in the same party, but you are my opponent. I can say anything I want to say about you, and it can be printed. That is the annoying part of it, because it is the big boys that controls the media. The convention, but the big boys controls it, and they have their allegiance to some people. So it's a huge issue, and I think that the conversation should not end here. We should find a way to make it come down, trickle down to places like third world. I don't want to use the word third world country, actually, the global south, actually, so that somebody somewhere will be pricked of his conscience. We can prick somebody's conscience, and there are several ways we can do this. I just want to mention, like I mentioned to you in the other time, we can start by the local chapters of the law associations. We can start with the law schools. We can also go into like community engagement. We can go into like talking to judges, you know, because some of these infractions take place in their courts and they don't have anything to do. They don't know, they're not in control of it, because in most cases too, they're also acting on the instruction of somebody that is above somewhere. You know, so it's such a serious and complicated issue. But by and large, I want to thank you very much for this opportunity to listen to gentlemen like you, and I quite appreciate And it's running late here, and maybe I have to stop here and then close for the work, close for the day. It's 6:01 p.m. Nigeria local time, and I have to use about 1 hour and 30 minutes before I go to my location. So I think this is the best place for me to stop. Thank you very much for the kind attention. I appreciate it.
Thank you. Thank you very much for your comments.
Thank you so much. Are there any final other comments, different perspectives, different things that you'd like to raise with Professor Resta while we have him here? I think, should I go ahead?
Yeah, can I ask a question?
Yeah.
Yes, thank you. It's just, I would like to ask, what is your intuition? Because I don't think there is a clear answer for this question. That dignity became such a door for this type of cases after 2014 or recently, because it's a category, it's a notion that has been going around for quite a long time. Why now? What is that makes a difference that has become so central?
Well, it's a very interesting but complicated question. I think that we can give a technical, narrow explanation and a broader cultural explanation. The technical explanation is that dignity as a legal principle in Italy has been largely unappreciated until the 2000s, more or less. It became a principle used by the courts for make things as a result of several factors, but not lastly, the fact that in 2000, the European Charter of Fundamental Rights was adopted, and Article 1 of the European Charter, which is modeled on the German Constitution, says that human dignity is inviolable. It has to be protected and respected. And as a result, there was an intense confrontation of the scholarship and case law, not only in Italy, also in France, the same story, with the principle of dignity, which was a typical German legal provision and principle. The president of the European Convention that wrote the European Charter of Fundamental Rights said there's a dignity is like the sauerkraut, is like the croats. It is something that many have. It is not only the Germans that have dignity, but we are the specialists of it. So as a sort of imitation of legal models, dignity became a legal principle starting in the 2000 in Italy. And one of the results was also in this particular form of litigation, but this is not the only one. In many other cases dealing with private law, criminal law, dignity was intensely used by the courts. And the second answer is cultural. The new generation of judges that sit today in the Constitutional Court and the Supreme Court are the judges that in the 70s were part of the civil rights movement, were part of the progressive renewal of the judiciary in Italy, and was a very famous development in Italy. And so the new generation of judges transposed the new values into the adjudication. And this is sociological, but it's very, very true.
Thank you very much.
You're very welcome.
I just want to, I think you've given us so much to think about. And I too was taking notes furiously throughout your presentation, because there's so many different ways in which different aspects of dignity that you were talking about sort of connect with different parts of all of our work in different ways and are thinking about it. So I just want to thank you for just a fantastic presentation. It's really given us a lot more to think about and a lot of avenues to fundamental questions, as you say, about law and justice and law and politics, and sort of the merging of public and private, and the power that dignity has that is becoming so great that it's even becoming sort of in confrontation with fundamental notions of state sovereignty. And I think that's just sort of the next challenge for dignity law, to sort of see how we're going to work in those areas, as Lubin raised and as others have raised. So I would invite everybody to unmute themselves so that Professor Resta can hear our applause this time. So thank you very much for just a fantastic presentation. Thank you very much. And thank you all for joining us. It's wonderful to see you all. And please join us again next month when we will hear more from Stefan on March 11th. And he'll be talking about his experience in Korea and also his previous experience, really taking a very deep dive into the role of dignity in law in Bhutan. So that'll be another fascinating conversation. So thank you very much, Giorgio. It was really a pleasure. And thanks to all of you. Bye-bye.
Thank you. Bye-bye.